Good day. Welcome to Apple Property Connection. I'm the Principal Petro Sciocatti of Apple Property Connection, and today we are starting a new series of legal updates. With me is Mr. Johan Muller, Director of Snyman de Jager Attorneys, well known in his field regarding all the laws and bylaws. Johan is going to explain to us today the Voetstoots clause.
With the introduction of the Consumer Protection Act, a lot of people thought that Voetstoots is no more, and therefore people cannot rely on the defense of Voetstoots. But unfortunately, or fortunately, that is not the truth. For the Consumer Protection Act to apply, the seller and the purchaser has to comply with the definition of a supplier and a consumer in terms of the Consumer Protection Act. Now, a supplier, or in this instance the seller, is a person who provides goods or services in the ordinary course of his or her business at consideration. And equally, the consumer is the person who receives those goods or services in the ordinary course of the seller's business. And in this regard, it's just not the case. Because if I would wake up one day and I would give Apple Properties a sole mandate to sell my property, and I'm a teacher, for example, I do not do this in the ordinary course of my business. But my business per se does not entail selling properties, and therefore the Consumer Protection Act, all its rights, all its obligations, and all its remedies simply just not applies. Now, in the absence of statutory law replacing our common law, the common law has to prevail. And therefore, Voetstoots, in my viewpoint, is still one of the most powerful remedies available to the seller currently, due to the very harsh burden of proof that the purchaser has to prove that the seller knew or reasonably ought to have known about the defect.